So the Kara are a tribe that live in southern Ethiopia on the banks of the river Omo. They've been described by anthropologists as almost Neolithic in their existence. They dress in skins, they hunt, they grow sorghum by the banks of the river, and they're autonomous. That's to say they get to make and administer their own laws without interference from the Ethiopian government. In the centre of their village lies a building which serves as their parliament and their court. And it's an ancient structure which is comprised of rows of tree trunks above which lies a low thatched roof. If a decision is to be made, the tribal elders enter the parliament building, but before they do so, they divest themselves of their clothes and all bodily adornments. The Kara are of the opinion that physical objects should play no part in a debate. The elders need enter only with their reason. And when inside the building, the elders line up in a half light in a way that they can't really see each other, because again, they believe it's undesirable that the physical presence of somebody should add undue weight to their words. They are to be just voices, points of reason in the darkness. And the voices debate with one another until there is no dissent. And the last voice of dissent falls silent, then a decision is made because they're speaking as one. Now, in Europe, after hundreds of years of thoughtful jurisprudence and many elaborate costumes, things are much more complex. Embryonic stem cell research is arguably one of the most important areas of medical research for the first half of this century. Nevertheless, to a greater or lesser extent, it's to be denied patent protection. Is it working?
You're already here.
Do you want to just... Don't desert me until we got the first slide on.
Do you have the presentation there?
Where's the computer?
Go to my computer.
Yeah. See, I've never been able to do that.
Is this it?
No, that's not.
It's not it.
Oh, I see. It is
on the USB, but it's not reading the USB.
Well, there are quite a lot of files.
Just arrived.
Oh, it's here now, yeah.
Get an ironic way.
The USB is a bit slow.
Yeah, it might be because it's somewhere.
This reminds me about the joke about lawyers and the light bulb. Which file is it?
Sorry. So, if you scroll down, maybe.
Sorry, there's a lot of stuff.
Can you not get them in date order or something?
Yeah.
Presentation, okay, at the top. Say right in that optimistic way. We'll think something's right. Good. Okay. Now, how do I make it go forward? That's fine. So, how do I go forward?
How do you go forward?
Like that?
Yeah.
Okay. Right. Excellent. Thank you very much.
Thank you very much.
Okay. So, stem cells are arguably very important, embryonic stem cells, but they're to a greater or lesser extent going to be denied patent protection. Does this matter? Now, as lawyers with an interest in IP, having listened to the professor, some of you may think patents are important. You may agree with the claim that they provide an incentive to scientific creativity. For myself, having spent 20-odd years listening to people tell me how they've arrived at inventions, I remain uncertain about this. I mean, human motivation is a complex thing. Sure, I can induce my children to do things with promises of material gain, but it's no substitute for a motivation born of genuine interest. But I think where we end up is that if people think patents are important, patents become important. The pharmaceutical industry faces particular challenges in the development of new medicines. I mean, it really, really does. The biotech revolution of the 1980s promised so much exponential growth in medicines. Progress has been steady, but it has been disappointing and nothing like we expected it to be. More recently, we have two powerful technologies. We've got stem cell therapy, which we're obviously going to talk about, but also a thing called gene transfer therapy. Again, still very few things have actually converted into the clinic. Now, this is a concern to shareholders. It's shareholders in pharmaceutical companies, that is, but it's also a worry for me, because I'm getting to that stage in life where my health is not assured. Pharmaceutical companies are responding to the challenges in a number of ways, but one particular way is that they're no longer investing to the same extent in primary research. One gathers as much from the financial press and statements made by the companies, but I also have direct experience of this. So for a number of years I've been sitting on a committee called GTAC, which reviews these cutting-edge technologies and decides whether or not to give approval to quite adventurous clinical trials taking place in man. And during the course of 3 or 4 years, I've probably reviewed, or the committee has reviewed, 30 or 40 of these trials. I think there's only one occasion when a major pharmaceutical company has presented to us, or even a medium-sized pharmaceutical company has presented to us. This sort of research, this really important research, is being carried out by start-up companies, by university departments, sometimes by individuals. And this is really important because these small companies need IP, they need investment. They need angel investors, they need venture capitalists, and eventually they'll need big pharma to come along and pay for their phase 3 clinical trials. These inventors want patent protection. Just to remind you, or for those who aren't familiar with the pharmaceutical industry, the average period of bringing a pharmaceutical product to market is 12 years. Estimates of the cost, there are a number of estimates. Some are over a billion euros to bring a product to market, but high hundreds of millions of euros are quite common. I assume, it's never really explained, I assume those figures include all the failures. I'm not sure that necessarily includes one particular product. But it's very, very expensive. European countries are signatories of the European Patent Convention, which I'm sure you're all aware. And this is the European Patent Convention, which gives us our substantive patent law, and it gives us the European Patent Office. The EPO is, of course, based in Munich, and that's the principal granting body for patents at the moment. The EPO and the European Patent Convention, of course, have absolutely nothing to do with the European Union. And indeed, some signatories to the European Patent Convention are not members of the EU. The EU has no working patent system. Nevertheless, in 1998, it produced a biotech directive which says certain things about the circumstances under which biotech patents can be granted. This is a very curious thing to do in the circumstances, and it did raise some serious constitutional conundrums. These have been largely circumvented by the EPO being consulted during the drafting of the biotech directive, getting hold of the text and turning it from a very anti-life sciences document into effectively a restatement of European Patent Office jurisprudence. The EPO then, with a flourish, wrote the text of the biotech directive into its implementing regulations, and these potential interesting constitutional problems largely disappeared. There have been remarkably few referrals to the Court of Justice under the biotech directive. There have been a couple recently, but there are an awful lot of cases that frankly could go to the Court of Justice. I've been involved in 2 recently. Neither side nor the judge suggested referring it to the Court of Justice, and the reason is because, of course, we don't have confidence that the Court of Justice knows anything about patents. If you were desperately bored, and trust me, you do have to be desperately bored, and were to Google the background of all the Court of Justice judges, you would see that the majority of them are not really judges at all in the usual sense. They're typically civil servants. Some of them are academics. and only a minority were practicing lawyers before their appointments. I'm aware of none having had patent experience or any IP experience prior to joining the court. And my personal impression from trips to the Court of Justice is they don't even have an elementary understanding of how industry works, still less the pharmaceutical industry, and absolutely no idea about basic concepts in life sciences. Now, both the European Patent Office, the Enlarged Board of Appeal of the European Patent Office, its senior court, and the Court of Justice have independently determined whether or not patents are to be allowed in relation to embryonic stem cells. The EPO sent out mixed messages, which I'll explain in a moment, and the Court of Justice ruled that they are not patentable. Now, embryonic stem cells are thought to have enormous therapeutic potential in regenerative medicine because they're pluripotent. That means the cells in an embryo can turn pretty much into any tissue you want, and of course that is what they do in nature, so to speak. They're created by removing the cells from an 8-day-old fertilized embryo. At that point, the embryo has two parts to it. It has a thing called a trophoblast, which is going to form the placenta and the chorioallantoic membranes and all the stuff to do with pregnancy. And then it has a very small lump of about 40 cells or so, which are going to go on and form the embryo. And these cells are going to form the fetus, rather. And these cells are undifferentiated. And you take one of these cells, and that is then grown up to create this culture of embryonic stem cells. In turn, those cells can be coaxed into producing neural cells or liver cells or heart cells or whatever. Now, the embryos that are used are what's called supernumerary embryos, and those are the excess embryos that are produced during in vitro fertilization. So when you engage in vitro fertilization, you produce a dozen or so fertilized cells. You implant a maximum of 2 if you're in the UK, and the others get destroyed. Not all stem cells are embryonic stem cells. There are other types. The 2012 Nobel Prize was given to 2 groups who worked on things called induced pluripotent cells, and this is where you try and take an adult cell and turn it back into an embryonic stem cell, or something equivalent to it. It's very clever, but it's a fairly new technology, and it's as yet unclear whether this technology is a good enough substitute to embryonic stem cells. An editorial in Nature recently suggested that they would never be as good as the real thing. But obviously, if they are, then the concerns about embryonic stem cells and their patentability may fall away. Now, why are stem cell patents said to be objectionable? Well, the starting point is really that you have to kill an embryo to produce embryonic stem cell line. Actually, there's a question whether you do have to kill an embryo, but seeing as the embryos from which you were taking the cell in the first place were going to be destroyed anyway, I don't think initially when this work started anyone really turned their mind to the fact as to whether or not it was possible to remove a single cell from the 40 cells, keep the other cells alive, only to destroy them a few weeks later. The legal basis, however, it all really stems from Article 6 of the Biotech Directive. Now, although this appears in the Biotech Directive, this provision is in the European Patent Convention and can be traced back a lot further than that. And it says, inventions shall be considered unpatentable where the commercial exploitation would be contrary to order public or morality. However, exploitation should not be deemed to be so contrary merely because it is prohibited by law or regulation. Now, this is the English version of the Biotech Directive, and the sharp-eyed amongst you will notice it has French words in it, which is never a promising start. The idea that we have concepts that we don't have the words for in the English language is a concern. But we're focused, I think, mostly on morality. So inventions should be not be patentable if they're contrary to morality. Now this is the second half of the article. It says, on the basis of paragraph 1, the following shall be considered unpatentable. So these are sort of by way of examples, and these were new in the Biotech Directive. So this doesn't appear in the European Patent Convention. And they start off, sorry the numbering's gone a bit funny, So processes for cloning human beings, well, one can see that's contrary to morality, so no surprise to see that there. Processes for modifying the germline, genetic identity of human beings, that's making changes to us which pass into subsequent generations. So one can understand why that might be there. And then there's the clause we're concerned with, which should actually be 2C, which is uses of embryos for industrial or commercial purposes. And it's this provision which is the one that has stood in the way of patenting stem cells. Now, we could spend quite a lot of time discussing the black letter analysis of what those words mean, but we're not going to today, you'll be relieved to hear. But take it from me, they're difficult to interpret. They can be interpreted broadly to cover stem cells, or you can construe them narrowly. From the Travaux, I think it's fair to say that when this was drafted, absolutely no one was thinking about embryonic stem cells. I think that's clear from the documents. And looking at these words, of course, you'll appreciate it. It looks as if you can patent some uses of embryos, but just not the use of embryos that's for industrial or commercial purposes. Now, those words for industrial or commercial purposes were actually added in at the request of the UK government shortly before the signing off on the Biotech Directive. To the patent lawyer, that limitation, of course, is difficult because all patents have to be for industrial purposes, so it's not entirely clear what it means. Now, the WARF case concerned the following claim. So it was not to a process concerning an embryo, it was to a thing, it was a product claim, and it was to a cell culture comprising primate embryonic cells. Don't worry about the rest of it. So WARF is actually the world's first spin-out company from the University of Wisconsin, and so it's Wisconsin Alumni Research Foundation, I think. And it actually was spun out because of warfarin, so it gave its initials to warfarin. And Jamie Thompson was the first person to be able to grow human embryonic stem cells. Now, what did the EPO do when faced with a patent like that? Well, they said it fell foul of paragraph 2C. That's not so much the interesting bit. The interesting bit is the argument that went on before the Enlarged Board of Appeal, and I would say that, wouldn't I, because I was involved, but there we go. But they were presented with some powerful arguments, not created by me, but by others, that based on TRIPS, the patent could only be declined if stem cell research was contrary to morality. Now, you may recall, I don't know if you know, but this is Article 27 of TRIPS, which the EPOs are signatory to and all the countries of the EPC are signatories to. And it says, subject to the provisions of paragraph 2 and 3, patents shall be available for any inventions, whether products or processes, in all fields of technology. So it places on signatories a positive obligation to grant patents, and there was good reason for that. In particular, the US going into the third world and insisting that you will grant patents without bias against particular technologies or bias against particular applicants. But there's this exclusion that we see in the European Patent Conventions. Members may exclude from patentability inventions the prevention within their territory of the commercial exploitation of which is necessary to protect order public or morality. Okay, so in order to be TRIPS compliant, you must grant patent, you must offer patents, unless it's contrary to morality. So the argument is very simple. How do you construe Article 6.2c of the Biotech Directive? You have to construe it in a way which is TRIPS compliant. And if it's ambiguous, certainly resolve that ambiguity by making sure it's only catching those things which are contrary to morality. In other words, address the question, first of all, is stem cell research contrary to morality? And then ask the question, does it fall within Section 2C? And if you've answered the question in the negative, then it shouldn't fall within Section 6.2c. Now, there's a bit of jurisprudence about that. I seem to have... Oh no, I've got it here. So the contrary to morality provisions have been considered by the European Patent Office before. And this is what they said in a case, this was some particularly horrible way of modifying a poor mouse for immunological purposes. But it said the provisions of Article 53A, which is the equivalent to the one we've been looking at in the EPC, are intended to exclude from patentability not subject matter that is controversial, but rather the kind of extreme matter, such as letter bombs and anti-personnel mines, which would be regarded by the public as so abhorrent that the grant of a patent would be inconceivable. And when the European Patent Office said that, they were absolutely on the money, and that, of course, is how it should be construed. Now, there's a body of case law, actually from the Court of Justice, concerning what morality is. And that case law sort of says two relevant things. First of all, if you're concerned with morality, you're looking for something that's European-wide. So if something is controversial, there's no common denominator, then as a matter of European law, and of course we're talking about Court of Justice jurisprudence, it's not contrary to morality. And second, the second principle which comes from that case law is if you're looking at morality, you don't just look at what is illegal, you have to find guidance in constitutional traditions of member states. So that would include the Convention of Human Rights and the Charter of Fundamental Rights, as well as the constitutional traditions of member states. Now, stem cell research is, of course, not illegal. It might be controversial. There are some people who don't approve of it, but there's no universal view that it is immoral. In fact, it has, in the past, been funded by governments, by national governments. It has, in fact, been funded by the Commission in the past. So it's no less controversial than perhaps contraception, abortion, in vitro fertilization, in respect of none of which is there a suggestion that they're universally held to be contrary to morality. Does an embryo have a right to life? Because, of course, there's this point that you're destroying an embryo. Well, that's been looked at by the European Court of Human Rights. There's a case of Evans in the UK, a very distressing case on the facts, but it was about a lady who had cancerous ovaries, and it was possible for her to extract ova from her ovaries before she had them removed. And unusually, they were fertilized by her partner at the time before they were stored. So they were stored as fertilized embryos rather than just ova. And then her partner withdrew consent when the relationship broke down. She wanted to have the embryos implanted and her partner objected. The European Court had to consider whether there was a right to life. So if those embryos weren't implanted, they were going to have to be destroyed, because under the British legislation, the Human Fertilisation and Embryology Act, it's actually illegal to store a fertilised embryo for more than 5 years. So when the 5 years was up, they had, as a matter of law, to be destroyed, and held unanimously by the court that there was no right to life. An embryo has no right to life. And of course, we only have to reflect on our own experience that society doesn't have absolute sanctity in life of an early stage undifferentiated embryo. We have abortion, we have in vitro fertilization, we have the morning after pill, we have the contraceptive coil, all of which will involve destruction of a newly fertilized embryo. One can look further. The Biotech Directive actually says if you want guidance on morality, you go to a thing called the European Group on Ethics. And that's a mixture of scientists and ethicists who are personally appointed by the President of the Commission. And they've given a number of opinions as to whether stem cell research is ethical or not. And in their 15th report, November 2000, they said that given that countries approve embryo research for the purposes of understanding fertility, there's absolutely no argument for excluding funding from embryonic stem cell research. No argument that it's contrary to morality. Now, if one puts aside the right to life, one may also want to consider the right to integrity, the right to dignity. In the Charter of Fundamental Rights, Article 3, there's a prohibition against making the human body and its parts a source of financial gain. And we're all familiar with that. You can't sell trading kidneys or any other parts of the human body. There's an exception in Italy, by the way. You can sell hair. But apart from that, we can't trade in the human body. But we also recognise, as a general matter, it's not immoral to commercialise cell lines. So one of the most famous cell lines in the laboratory is called HeLa cells. They were taken from a lady called Henrietta Lack in the 1950s. She had a cervical cancer. I mean, there's been some controversy around her particularly, but her cells were taken. These cancerous cells can grow up in the laboratory. They're very useful for research. There's actually, in terms of body mass, far more of Henrietta Lack in existence today than there was when she was alive. And there are a number of these cell lines, and you can buy them, you can patent them. So if you can do that if you can take a cell from my 7-year-old daughter and grow that up, why can't you take a cell from an embryo? So that's the background to the argument, saying, look, when properly analysed, stem cell research it just isn't contrary to morality. Why stretch the meaning of paragraph 6.2c of the Biotech Directive to make it embrace embryonic stem cell lines? And one can put other interpretations on use of embryos for industrial or commercial purposes. We'd all flinch, I think, at the idea of a cosmetic made of embryos reduced to a cream. So, I mean, there are other ways to think how that provision might be construed. Now, what happened at the EPO hearing? So, the Enlarged Board of Appeal were interested in this subject of morality, and they heard a whole day's argument on it. One has to be careful of the vanity of advocates, but I do think that they were engaged and particularly interested in the TRIPS argument. And at the end of the hearing, they said, well, look, that's really interesting. We're really fascinated by all this and all this case law on morality and so forth, and we'll give you a decision in 2 weeks. The board then went completely quiet, and this was at the beginning of July, and we didn't hear anything from until November. And when they produced their decision, they didn't address this question of morality in the decision at all. The TRIPS argument is glossed over. There's a single sentence, and then they said the WARF patent fell foul of 2C, and that's the end of the matter. Now, from a legal perspective, this is surprising, but what is arguably even more surprising is that the European Patent Office refusing a patent on non-technical grounds. I mean, the European Patent Office has patents in its blood and is prepared to slap a patent on pretty much anything. The second thing of note is the European Patent Office knew this matter was going to come before the Court of Justice. And in perhaps what was a mistake with hindsight, we actually made this clear to the European Patent Office. So the thinking was, look, you're going to look pretty stupid if you refuse a patent in this area, and the Court of Justice then go and grant one. You're going to look pretty stupid. So why don't you just grant a patent? Because they're going to be looking at this thing in due course. Now, I think that was a mistake. We even actually suggested to them they might like to refer a question to the Court of Justice, which they got very excited about. We never really expected them to do it, but a lot of them actually woke up and only really asked any questions when it got to that point. They didn't. They were very concerned about the mechanism of, I don't know, going out and buying a stamp or whatever it is you have to do. So that takes us to Brusley and Greenpeace. So this is effectively the same issue that went up through the German courts and went to the Court of Justice. Now, just for what it's worth, that was the Brusley patent. It had lots of different claims, but again, it had claims to things, isolated neural precursor cells, as well as some processes. And what did the Court of Justice do? Well, they reached the same result as the EPO. They said that this patent fell foul of Article 6.2c. Now, again, unfortunately, the case doesn't address any of the interesting questions. It revolves, and if anyone's read it or you do read it, you'll just see it's a long debate about what an embryo is and all that sort of stuff, which really doesn't really have anything to do with what we're talking about. There's no reference to TRIPS. There's no reference to the case law on morality. There's no reference to the opinions on the European Group of Ethics. There's no reference to the teleological purpose of the article. No, there's a short reference to human dignity, but no analysis as to does an embryo have a right to human dignity? Is it inconsistent with that dignity to remove a cell? Nothing at all. Importantly, what happened, sorry, just pausing there and going back. So what happened after the European Patent Office said it was going to disallow the WARF patent? It then kind of stepped back from that. So what it said is, okay, Jamie Thompson can't have a patent, but we're going to allow patents provided the patents are applied for after, I think it was about 2003. And the reason being that was then you could buy stem cell lines off the internet or through companies that sell such things. So you didn't have to kill the embryo yourself. Someone else had done that, and you were just taking the stem cell line and working with it to develop your neural precursor cells. So just looking at it from afar, it seems that the EPO is not wanting to make a controversial decision, perhaps not wanting to make a decision which is inconsistent with the Court of Justice, but it's leaving the door wide open to later rounds of embryonic stem cells as we get past that crucial 2003 date. Now, Bruslet, they said a slightly different thing. So this is in the decision of the Court of Justice. They say the fact that the destruction may occur at a long stage before the implementation of the invention is irrelevant. So when we saw this, we all thought, well, how's the EPO going to respond to that? That doesn't seem consistent with this 2002-2003 cut-off. Now, whereas the court didn't explain why, as a matter of law, embryonic stem cell research was contrary to morality, the AG was less diffident in his opinion, which is AG Bott, and this says it must be agreed that inventions relating to pluripotent stem cells can be patentable only if they are not obtained to the detriment of an embryo, whether it's destruction or modification. To make an industrial application of an invention using embryo stem cells would amount to using embryos as a simple base material. It would seem pointless, indeed superfluous, to mention ethics and ordre public. And so I think the correct interpretation of that is it's so unarguably unethical that one doesn't even have to discuss it. Okay, so where does this leave us, and why is this important? Well, I think it says a lot of things about European institutions. This debate is not about the definition of an embryo. So you pick up a judgment and it's all about the definition of an embryo, but it's not about that. This is fairly and squarely about religion. To ignore this is to entirely misunderstand what is happening in Europe in relation to stem cells. Now, none of us know to what extent the court had in mind a desire not to upset the Catholic Church. But I think the AG's language suggests that the underlying this is an assumption of immorality. And that assumption, if one traces it back, is founded in Catholicism, and interestingly, not shared by other religious organisations. The Vatican has taken a particular interest in stem cell research. You may remember that they actually had a conference on stem cell research on induced pluripotent cells. I mean, I'm taking this matter pretty seriously. In fact, one of my colleagues went to it. It's often said that the European Commission is sympathetic to the Catholic position on a number of issues. Now, one needs to be very cautious about saying things like that, but there is some objective evidence, and I just want to give you two examples. My absolute favourite is the Buttiglione affair. Does that mean anything to anyone? No. Okay, so it was a little while ago. Now, in 2004, the newly appointed president of the Commission, Barroso, who, by the way, is a Jesuit-educated Catholic, supported Rocco Buttiglione's appointment as a European Commissioner. This was highly, highly controversial. Buttiglione was personally extremely close to John Paul II and is a highly influential religious fundamentalist. He's publicly stated and repeatedly states that homosexuality is a sin. He's opposed to abortion, he's opposed to artificial insemination. And wait for it, he was to be Commissioner for Justice and Freedom at the Commission. I mean, you really couldn't make it up. This caused such outrage in the European Parliament that they refused to endorse the appointment of any of the commissioners. And this caused sort of 6 months of turmoil at the Commission. Eventually, his nomination was withdrawn. But throughout that time, the President supported him up to the hilt. He offered personally to chair meetings on behalf of Buttiglione if it was felt that it was on an area where Buttiglione might have expressed views. The second example, which occurs from around about the same time, is the European Group in Ethics in Science. I mentioned to you that they had said that there was no issue about the morality of stem cell research in November 2000. What Buttiglione did is he reappointed that committee. So in June 2007, and I think he reappointed half of them if I recall rightly. So in June 2007, they were asked to write another opinion on embryonic stem cells, concerned with funding under FP7. And the committee states at the beginning of that they're divided as to the morality question and they can't express an opinion on it. Given this background, and I appreciate one is talking about the Commission and not the Court, one must wonder whether or not dancing around the technical definition of an embryo had anything to do with the case at all. And notably, we see no reference to the plight of patients suffering from degenerative disease. I don't know if any of you have been unfortunate enough to be close to someone who's suffering from a degenerative disease, but it really, really is absolutely horrible. Importantly, the AG's opinion, we looked at a little bit of it, opens with the observation, and I find this extraordinary, that this issue, which, by the way, everyone knew was very important, was regarded as very, very sensitive. Okay? If it was just a construction of 6.2c, why was it sensitive? She said it was very, very sensitive. And he observes, consequently, only 2 member states were prepared to make oral submissions at the hearing. I've been to SPC hearings at the Court of Justice of absolutely no consequence when pretty much every member state wants to stand up and stick its pennyworth in. The UK wasn't prepared to turn up, by the way. Now, this is too important an issue to be avoided, in my opinion. My personal view is that the Catholic viewpoint is perfectly legitimate. Catholics are absolutely fully entitled to persuade European institutions to their point of view. But these issues have to be confronted head-on and debated in the context of the correct legal framework. Judges are there, and indeed governments are there, to grapple with difficult issues and not to dance around them because it makes them feel uncomfortable or because they are unduly sensitive. If they don't want to decide difficult issues, they should do something else, perhaps become traffic wardens. Now, this case is important, just to finish off, in it for a number of reasons. First of all, some of us in this room, or our relatives, will suffer horribly with degenerative diseases. We should really care that stem cell research, which frankly is the best prospect we have if we're facing strokes or cervical spinal lesions, we should really care that it's not getting the full support of the state. Second, this, to my mind, tells us something about the way that European institutions work, and it also says something about the relationship between the European Patent Office and the European Union. Now, neither institute is answerable to the other, and here we've said we've had them ruling on the same point. My reading is that the EPO produced a decision which you would believe would be consistent with the Court of Justice, while at the same time following its instincts to give it space to grant some patents in this area. The Court of Justice has gone further, and what the EPO did, the president of the EPO, who's Battistelli, within a few days of the Brusley opinion coming out, made the following comment on his blog, and it really is worth looking at. I mean, everyone has a blog, don't they? Even the president of the European Patent Office. But it really is actually worth reading carefully. In the last paragraph, and it's anyone's interest, 3rd of November 2011, It says, if judges rule in favour, so he's referring to the Brusley case, if judges rule in favour of a restrictive interpretation of biotech patentability provisions, the EPO will immediately implement it. Well, why? Why will the EPO immediately, as if, I mean, they're not your judges. And to say that so quickly, not we'll look at this again or we'll consider it, will immediately implement it. Why? Why? Well, the reason is there's a big turf war at the moment going on with the unified patent. Is the EPO going to be out of a job? You know, they're trying to keep in with the European institutions and so forth. Okay, but then he goes on, the European legislator may decide that further changes to the law are needed. Whatever is decided, I welcome evidence-based debate and invite all interested parties, especially associations active on these issues, to discuss them with us on the basis of objective data. So that's a pretty clear statement to me that they don't agree with that decision, and the legislator might like to look at it again, and they want an evidence-based debate on it. So, interesting to see where the balance of power lies. Now, the Brusley case, just for completeness, so the EPO after that stopped granting stem cell patents at all, just not granting anything that could possibly embrace an embryonic stem cell. This is what I'm hearing from patent attorneys trying to get these patents through. Now, then there was a change, so there's been a further decision in the German courts. So Brusley returns to the German courts, and then they narrow their claims. So they exclude methods which require methods which require killing an embryo. And interestingly, the German government have now said, or the German courts have now said that that patent can be granted, and it doesn't have to go back to the Court of Justice. So how the EPO is going to respond to that, I don't know. We will have to watch. How serious is it for stem cells? Okay, so let's assume that this carries on at the breadth that I fear it may, and that there are no patents. Well, funding has been gradually draining out of stem cell research. So it used to be funded by the Commission. I think the Commission were putting in 20 million euros a year into embryonic stem cell research at one point. Under the FP7 funding, that was qualified, and they took a line which is very similar to that in Germany, and they said they will only fund stem cell research if you don't kill the embryos. Okay, so if someone else has done the killing of the embryos, created a stem cell line, and you're now working with that stem cell line, they'll fund it. But they won't if you're going to be destroying the embryo. But recently, as a result of the Brusley decision, the European Parliament is now debating the multi-billion euro Horizon 2020 investment. Said this, at least according to Nature. They said the Legal Affairs Committee of the European Parliament voted last week, this is in October, voted last week for its exclusion, that's the exclusion of embryonic stem cell research. Referring back to the controversial decision of the European Court of Justice last year that the use of human embryonic cells in research was immoral and therefore unpatentable because it had once involved destruction of an embryo. The Legal Affairs Committee argued that since such research was unpatentable in Europe, it could not contribute to European competitiveness, and since the main aim of Horizon 2020 is to stimulate European competitiveness, such research should not be funded by the programme. Many legal experts consider this reasoning false. But it brings us full circle to what I was saying at the beginning, that if you believe patents are important, and here's the European Parliament believing they're important, it's just not going to be prepared to fund embryonic stem cell research, not because of the morality issue, but just because you can't get patents. So there we are. That was all I was going to say, given the time and the weather.